So we're fortunate enough to have two excellent speakers with us today. First, we have Chris Davis, who is our Government Investigations and Compliance Practice Group Leader for Gray Reed. One of the many areas he tackles is the complex legal issues surrounding data privacy and cybersecurity. Joining him is Lynn Rohland. She leads the cybersecurity and data privacy solutions for our advisory arm. She brings over 3 decades of expertise, essentially bridging the gap between the privacy policies and operationalizing them into business environments. Without further ado, let me hand it over to Chris and Lynn to share their insights with us.
Great, thank you, Vicki. So today, Chris and I wanted to share a visual of what the global privacy landscape currently looks like. And I'll caveat, this is far from being comprehensive because it doesn't capture the privacy regulations from around the globe, nor the fact that there's about a third of the states in the US that have privacy laws currently. I think it's like close to 17 or right at 17. So with the limited amount of time that we have today with you, Chris and I are just focusing on the Texas Data Privacy and Security Act, or TDPSA for short, and becoming effective July 1st, or basically in less than 7 weeks. So in a sentence, when we just described the law, it states exactly what the requirements are for collecting personal data, processing it, and the necessary consent practices, notifications, and disclosures needed for compliance. And this is largely affecting consumer-facing companies that are engaging with Texas residents. So, Chris, can you share some of the insights on the landscape before you lead us on the next topic?
Sure, and thanks, Lynn. And as Lynn mentioned, there's kind of a couple components to it. There's the component of the legal landscape and how all these various things on the screen fit together. Texas borrowed from a lot of other statutes that are already in place, both at the state level and really internationally. There's certain components, for instance, standard language that's required under the Texas statute that's borrowed from actually the GDPR, which many of y'all may be familiar with, but it's very normal in our experience to have companies that are actually subject to multiple of these laws, and then we have to figure out how all that fits together. So like Lynn mentioned, we're going to focus on Texas today, but that doesn't mean that if you're good under Texas that you're free and clear, because all these laws kind of reach out and touch you wherever you are, as long as you're dealing with residents of that state, or even have touches in that state or that jurisdiction, I should say, because it's not always state-based. Sometimes it's country-based. And it'd be nice for us here if we had one that was country-based, but we're not there, and who knows when we'll get there. So in the interim, we got to do with what we got. And then the other component, aside from the legal component, is the operational component, which Lynn mentioned and which she specializes in and has for 30 years. So I think that's kind of the lay of the land.
Yep.
And Lynn, this may be, well, let me touch on the legal components of this,
Sure.
and then because it's fairly straightforward, and then Lynn can touch on the kind of business components, because there's a potential legal cost here for companies that are non-compliant, and that's kind of vested within the Texas Attorney General's office. Texas is in line with most other states, the lone exception being California, in that it's up to the state to enforce violations, which means the Attorney General's office is vested with the authority to investigate and prosecute any violations of the act. Now, California, there's a private right of action, which means that if you're not compliant under California law, you may have plaintiffs' lawyers beating down your door, which, depending upon your perspective, plaintiffs' lawyers may be more scary than the government. But the bottom line is, under the TDPSA, a company can be penalized $7,500 per violation. So that can add up quickly. And for any of y'all who have dealt with government investigations like we do over here all the time, the AG also has a lot of the typical investigative tools For instance, the AG's office can issue civil investigative demands that ask for a lot of information having to do with a company's policies and procedures and whatnot. There's going to be an online portal set up where anyone can report a potential violation, which would then end up on the AG's radar for potential investigation. And so, essentially, if you end up in that boat, you're looking at the per violation charge along with, the cost of remediating, going through an investigation, et cetera. Now, this is something where this kind of covers legal and business side of things, but I'd highly recommend that you look at what your insurance covers right now, because we always enjoy dealing with clients that have insurance for these types of things, but a lot of times there are carve-outs and you may think that you've got coverage when you don't. So that's another thing that we recommend that you consider just as you prepare to comply with this thing. And maybe even if you are compliant, that doesn't mean you're going to avoid an investigation.
Yeah, so Chris has obviously helped many clients navigate the complexities of a data breach and reporting and some of the legal implications. But not all data breaches necessarily have the result of penalties and fines that we see. And so as Chris alluded to earlier, there are other costs and I've seen this with our clients where they've had a cost of a technical subject matter expert that performs forensics that comes in, the cost of the time that it takes to report to state officials or to bring in the FBI, the cost of administering notifications to the affected individuals, and then of course, any potential loss of revenue resulting from a breach that impacts the brand or reputation of an organization. I think it's important to note where some, I wouldn't say clients, but where organizations that are like, I think that we're low risk and if something happens, we'll just lawyer up. And that's great for Chris, right? Because Chris helps you navigate these kinds of things. But if you are able to put in some of the effort up front to have even, the basics of a program, it helps because the impact of a data breach on an organization with just fewer than 500 employees amounts to $3.31 million. Again, less than 500 employees, a data breach can cost on average $3.31 million. And that kind of averages out to, the cost of a record at about $164 per record, or 3.31 million is 20,000 records. So food for thought, a reference point for folks. I think on the next slide, we want to talk a little bit about the impacts, get into a little bit more granular level, not so much the cost, but yes, this takes time and effort and resources. Based on our past experience and even some current clients, TDPSA will impact companies from a compliance perspective. If you don't have a privacy program, if you've been, the growth has just been exponential and you haven't been able to keep pace with that on some internal infrastructure or programs, maybe you only have very minimal components in place, or it's ad hoc, you have a policy and annual training. The impact to you is that you're going to have more ground to cover to be compliant with TDPSA. It might be a heavier lift depending upon what your business model is and what industry sector that you're in, just to get compliant. I can speak a little bit on assessments and governance, and then I'll turn it over to Chris to give some of his flavor and feel on what he's seeing as the impacts. But, ideally from an assessment perspective, you would begin with a baseline, assessing your current state, and compare those results to what the compliance state should look like to TDPSA. And that gives you the foundation to identify not only your compliance gaps, but really, if you've performed a thoughtful and meaningful assessment, you can really get a good insight on your privacy risks that need to be managed as well. From a governance perspective, I think the impact is what we've learned from many of our clients is they have a lack of in-house privacy expertise. Some may have an attorney who's written a policy, and while that is critical, it's only a piece of one part of a bigger pie. And this is a multifaceted discipline, which you'll see as we continue to talk about, between assessments and policies and procedures and bringing in IT security and data privacy agreements. You need somebody who's a Swiss Army knife. I guess that's the point that I'm trying to make. And so, having someone at least initially help you stand up or give, more lift to an existing program that you have in place. You just need to get the basics and fundamentals of your privacy practice in place, and that's super key. So that's, those are some of the impacts from compliance, assessments, and governance. Chris, would you like to kind of share some of your thoughts on this?
Yeah, sure. And before I do that, housekeeping item that I think we may have missed at the start. We do have the chat open. We would appreciate any questions, and some of them we may be getting to in the coming slides, but this will certainly be better if you've got questions. But the only thing I think I would add to what Lynn said, a lot of the things that you see on the slide, for those of y'all who are familiar with this area, have been best practices for quite some time, right? But the big thing about TDPSA is they've kind of, a lot of these things have moved from best practices to legal mandates. And for instance, the privacy policies, that's now mandated if you're dealing with folks who are defined as consumers under Texas law, which we're going to get to in a minute. Likewise, periodic assessments of your data privacy, how you control and manage data, those things are now mandated. I mean, again, we've always recommended these things as best practices. Likewise, that you do tabletop exercises and things like that so that you're prepared in the event of a breach. And Texas has had a law that covers breaches for a while. But now we've got all these affirmative obligations that are no longer just best practices, but legal mandates. And you may have the state come in and take a look at what you're doing, even not having had a big data compromise incident, and still, end up in hot water over that. So to me, that's the big change, right? Is that there are now all these affirmative things that you have to do that are no longer just industry best practices, but rather mandated by the law.
Yeah, and Chris, you mentioned that Texas has had breach law in effect for a while now. Just to remind folks, the Texas law requires businesses that experience a data breach that affects 250 or more Texans to report that breach to the AG as soon as possible, but certainly no later than 30 days after the discovery. So I think that's a good thing to underscore. Yeah, so who does TDPSA apply to? It's any company or individual that meets basically 3 criteria: conducts business in Texas, or produces a product or service that Texans use. It does not apply to employee data, and I say yet, because just like CCPA, the California privacy law, it at first did not apply to employee data, and then eventually it did. So for TDPSA, you have a buy. For how long, we don't know. It could be amended in the future. It applies to any company or individual that processes or engages in the sale of personal data. So this includes maintaining personal data of consumers, compliance clients, and business partners. But I know you might have it up, Chris. how they define sale, because sale isn't always a dollar monetary transaction. I don't know if you want to kind of scoot in and
Yeah,
share that.
to jump in on that point, the statute kind of gives and takes away on points. On consumer, it does provide an exemption for commercial activity. So
Yeah.
the person has to be, or person or entity has to be acting in an individual or household context. So for instance, if you're a business that only deals with other businesses, then that would not be triggered. Conversely, sale is defined broadly. And it doesn't just mean that you give your customer data that's collected during the course of your business to a marketing company for money. Anything of value could conceivably come within the definition of sale. And so, like I said, it kind of gives and takes away, right? Because the definition of sale is very broad here. And so if that data is being used in any way, shape, or form, and shared in a way that can benefit your business, you're going to get brought within the statute. And it covers, this is not explicitly on the slide, but for those of y'all who are familiar with the EU or some of the other statutes, it covers both processors and controllers. The controller would typically be if a consumer buys something from your business and you collect that data and it goes into your database or wherever it goes within your system, you control that data. Now, you may work with other businesses who are processors who need that data to do what they do for you. And so it covers them too. And so for those of y'all who have dealt with this type of situation, again, we've done contracts, for instance, for people who fall under the GDPR. There's certain language that you need to put in the contracts with your business processors, business partners, to ensure that that piece of it is covered too. So the point is, there's a lot of technical tentacles. Having a little trouble talking there a moment, but a lot of tentacles to the statute.
Yeah. And thanks for that, Chris. I think that was helpful. The third and final criteria is that you're not a small business. And small business is defined by the Small Business Administration, the U.S. Federal agency, the business, Small Business Administration. So the SBA, you would have to go there and look at that again. It'd be useful to make sure that you're working with legal counsel when you're looking at this. I think the only caveat to being, an SBA and being exempt is if you sell personal data, and then that triggers it. So.
Yeah, just to piggyback there, that's a legal analysis in and of itself. The SBA, you can go to the SBA website and find guidance on what is and isn't a small business. But for instance, for most manufacturing companies, if you're under 500 employees, you're probably going to fall within that definition. But most, because it's based on specific industry categorizations put out by the SBA. Conversely, if you are non-manufacturing, you're less than 7.5 million, you're probably within the definition. But I kind of like the way Texas did it because it leveraged existing law. The only downside to it is it requires a legal analysis in its own right to see if you qualify. But it does kind of marry up with existing law. And I do see a message in the chat that asks, does this include email marketing as long as there's criteria to unsubscribe? So if you're dealing with consumers and by email marketing, you're selling consumer information so that they can be marketed to, then it would apply. And in a minute on one of these slides, we're going to get to consumer rights, which include opt-out rights, among other things.
Yeah. So we have a 10-minute
Oh,
check.
and I also do see, are there exceptions for nonprofits?
Yes.
And hopefully whoever wrote that is a nonprofit, because the answer is yes.
Yep.
And we're about to, I think that may be on a slide, but if it's not, the answer to that is there are exceptions for certain government entities, nonprofits, and the like.
Yeah, again, if you're not selling personal data, that's the only time when you'd hit the tripwire that it would be.
Correct.
Yeah, so moving along, the major mandate, central tenets, as we call them, areas that you want to make sure that you have processes in place for enabling consumer rights requests if they want to have their data, they want an accounting of what you have of them on file, if they want to make a correction, if they want a deletion, just being able to enable those kinds of abilities. You also need to comply with the procedural mandates that are articulated with managing those requests. So it's not enough that, hey, we have a way for you to contact us and tell us what you want, but you have to do so in a way that's compliant with what's stated in the law. That just means that you really should have a repeatable process that's in place to receive, track, and respond. I think it's within 45 days to respond to the request. You can get an extension, but you also have to let the consumer know. And you'll have to include an appeals process to the consumer in case you deny it. You explain why, and they say, no, I want to challenge this. You need to provide them with a process by which that they can appeal it. Let me, I guess, throw it over to you, Chris, if you want to add, the last couple of thoughts on that before we move to the next slide.
Sure. And just to circle back, because I was looking up the list while we were talking. Exemptions that do apply include nonprofits. Again, with the caveat that Lynn gave a minute ago, that you're not selling personal data. But they apply to nonprofits, state agencies, and political subdivisions. No surprise that the politicians carve themselves out. No offense to any politicians on the call. Financial institutions, subject to Gramm-Leach-Billy, entities covered by HIPAA and data covered by HIPAA, and institutions of higher education. And so you can see that the carve-outs kind of largely apply to entities already covered by other data privacy and protection laws. And then I forgot where you left off, Lynn, but I think we were over on the right side. As I alluded earlier to, there are certain contractual requirements that are going to apply between controllers and processors, which is kind of a fancy way of saying you and your business partners, to the extent that they have access to your data and might be processing your customer data. There are opt-out mechanisms that have to be available, and they also have to be readily accessible. I'm sure a lot of y'all go to a website that may say, click this acknowledgement, we're going to collect your data. Well, that's a problem. Right? You can't, it's not a one-way street. The consumer has some control over what's collected, how it's used, whether it would be deleted. They're entitled to know what you collect, what you do with it. There's all sorts of things. You got to have certain policies and procedures that do certain things. One thing Lynn and her team is really adept at is going to your website and looking at your existing privacy policy and seeing if it complies. That doesn't take much time at all. So that's something that we regularly do to issue spot. But just be aware that just like we can do it, others can do it. So
Yeah.
all your public facing stuff, you need to be exceptionally careful about.
Yeah, I do want to answer one of the questions, which is what are some of the typical business activities on which TDPSA would apply outside of the fact of, whether you sell information or not. And I think a typical one is you go to a website and let's just say you sell homes and or insurance online and somebody wants more information. If you have a website that provides the ability for consumer interaction, even if they don't buy, even if they're just looking for information and they enter their name, their phone number, address, email address, postal mailing address, whatever, that's enough to trigger it. It really is, because now you are collecting. There's even some instances where, might not be collecting that type of information, but they are tracking. They're using cookies and tracking technologies. And then there again, that's enough as well, because then there's there is that kind of activity that would trigger some privacy requirements. I think we ought to skip the next slide. I can make one sentence on it, just in the spirit of brevity, is that at the end of the day, you really should have your basic blocking and tackling privacy components in place, policies, repeatable processes, so that you can demonstrate that your practices are activated and operationalized. I think that's so important. I don't know if you have anything you want to add to that, Chris, because I noticed we've got 4 minutes left.
Yeah, I'll add to it. As somebody who spent 10 years with the government, one of the government's biggest hot button issues is that you've got these nice, pretty pristine policies that sit on a shelf. If they come in, and even worse is just kind of the boilerplate policies that maybe you took from something you found on the internet, or you've got a generic compliance consultant that comes in and says, we can give you these policies. I mean, you need to be able to show 2 things. One, that these things have been thought through and tweaked to your individual business. And then the other thing you need to show is that you've actually put them into place. I can't tell you how many times when I was with the government, we'd look at the policy, and what they did in practice didn't have anything to do with what the policy said they were going to do. And that's a huge problem. And that's, again, just a huge hot button issue for the government, because they don't like the box ticking and the just saying we've done it when you really haven't done it. So that's the only thing I would add on that point, because that's their view of the world. And again, I can say that I haven't lived in that world for about 10 years.
Next slide. Gonna be a little bit of a sprint here. So some practical steps. I think we've mentioned a lot of these already. Research and understand what's applicable to your organization now, and potentially look at your longer term 6, 12, 18-month, 2-year business strategy, and make sure that you're thinking about data privacy and the requirements and getting them integrated. Knowing what's required, you'll want to baseline where the organization is, so that you can understand where your compliance gaps are and mitigate them, and remediate them and mitigate any risks. You take those findings, you prioritize them. There's only so much time, so many resources and budget, and you put it into an action plan. But I would say your action plan, if I'm a regulator, the first place I'm going to go is I'm going to go where your website is. And I could read a website, analyze it, and I'll have a pretty good idea whether this organization is compliant or not with their data privacy policies just from reviewing it. Make sure that you have identified where all your data is, who has access to it, and for what purposes, and how it's safeguarded. It's called a data inventory. Is it mandated? No. Does it help? It does a great deal, whether it's responding to consumer rights requests, or if you have the unfortunate experience of a data breach. But let me stop there and let my colleague come in.
Sure. And I think I agree with every bit of that. I can tell you that in my experience, we usually find issues just right there at the understand end of the spectrum before we move forward. And that's totally understandable, because, this is just one of those things. It's not necessarily a profit center for your business, and especially businesses that have acquired other businesses over time and have disparate systems. You just don't always know where your data is. And so if you can't answer that question, then you really need to get that figured out first.